everyone, welcome to Law Watch. My name is Raina. I'm the Immigration Legal Assistant here at Coleman Jackson PC, and our topic today is VAWA and alternatives for abused immigrants. I will be presenting several questions and sharing with you the answers that Attorney Coleman Jackson provided about this very important topic. So let's get started. Question number one is for the attorney to give us a brief description and history about VAWA, and the following is the attorney's answer. Congress first passed the Violence Against Women Act in 1994. This large federal law contains provisions that allow spouses and children abused by their United States citizen or lawful permanent resident spouse and parents abused by their U.S. citizen sons or daughters to self-petition to get a green card. That is, without having to convince the abusive relative to file the petition. And for reference, I will be using USC to mean United States citizen and LPR to mean legal permanent resident. The immigration provisions of VAWA are an attempt to correct a very widespread problem. Many immigrants are forced to stay in an abusive relationship because their abusive family member can hold them ransom due to their immigration status. For example, too often an abusive spouse will refuse to file a family visa petition in order to control an undocumented spouse. Or the abusive spouse will threaten to withdraw a petition or even call officials at the Department of Homeland Security to deport the immigrant spouse if he or she attempts to leave, to resist the abuse, or call the police. Furthermore, under President Obama, there was a reauthorization that included a non-discrimination provision. This means that applicants were not to be discriminated against because of their race, color, religion, national origin, sex, gender identity, sexual orientation, or disability. Additionally, the House of Representatives has recently passed the Violence Against Women's Reauthorization Act, which renews and strengthens this law. This expansion grants protections to Native American women and survivors from underserved communities and improves efforts to prevent intimate partner violence. So now question 2 states, why did Congress decide to pass VAWA? The answer is that Congress did not want to see U.S. immigration laws used as another weapon in an abuser's arsenal. So it created VAWA to permit a spouse or child in this situation to self-petition on his or her own without having to rely on the abusive spouse or parent to file the visa petition. In 2005, Congress expanded these provisions to permit parents of abusive U.S. citizen sons or daughters to also self-petition. So VAWA is a very important tool that people who are being used can rely on if they're being threatened because of their immigration status. So question number 3 states, what benefits come with VAWA? Well, VAWA provides these self-petitioners with some benefits that go beyond those available in regular family visa petitions. As long as the self-petition is approved, even if no adjustment application has been filed, the VAWA self-petitioner can legally work in the United States and will not be deported during the months or years it may take for the petitioner's priority date to become current. Plus, VAWA self-petitioners can apply for adjustment of status in the United States rather than having to leave the United States to process their visas at a consulate in the home country. Also, the VAWA self-petitioner can receive many public benefits unavailable to other non-citizens. Question 4. Are only women allowed to apply for VAWA, or are men and people of a different sexual orientation allowed to apply too? And while most victims of domestic violence are women, but it's important to note, however, that men sometimes are the victims of domestic violence and women sometimes the abusers. The VAWA immigration provisions benefit both abused husbands and wives, as well as abused children and parents. And like I stated previously, under President Obama, there were new provisions passed by Congress that included protecting people from the LGBT community and Native Americans. VAWA also protects children abused by a USC or LPR parent. And frequently, even if the child was abused and the parent wasn't, the non-citizen parent may also qualify for VAWA. Or if the parent was abused and the child wasn't, the child may also qualify. Question 5. What are the requirements to self-petition for VAWA? The self-petitioning spouse must prove that the abuser is or was an LPR or USC. The self-petitioner is or was the spouse of the LPR or USC abuser, or the parent of a child who was abused by the self-petitioner's LPR or USC spouse. The LPR or USC abused the self-petitioner during their marriage. The marriage that forms the basis of the self-petition was a good faith marriage. Either the self-petitioner is residing in the US, or if living abroad, the LPR or USC abuser subjected the self-petitioner or her child to abuse in the United States or is an employee of the US government or armed forces. The self-petitioner lived with the abuser. The self-petitioner is a person of good moral character, and in some circumstances, the child of the abused spouse qualifies for status even if the child herself or himself was not abused, and the parent of an abused child qualifies for status even if the parent herself or himself was also not abused. So question 6. What behaviors qualify as battered or extreme cruelty for a victim to qualify for VAWA? And while USCIS may consider a wide range of behaviors, including where the USC or the LPR spouse did the following: threatened to beat or terrorize the victim, hit, punched, slapped, kicked, or hurt the person in any way, emotionally abused, such as insulting the person at home or in public, sexual abuse or exploitation, including molestation or forcing sex when the person did not want to, or forcing the person to prostitute themselves, threatened to take away the victim's children or hurt the children in any way, threatened to deport the victim or turn the person over to immigration, controlled where the victim went, what they could do, or whom they could see, forcibly detained the victim, engaged in a pattern of acts that alone would not normally constitute abuse, threatened or committed acts of violence against a third person or thing in order to scare or pacify the victim. And question 7, does the self-petitioning victim have to live in the United States to apply for VAWA? A self-petitioner does not have to continuously have physical presence in the United States to file the petition. A self-petitioner who recently moved to the United States can qualify, and non-citizens living abroad can self-petition if A, the abusive spouse is an employee of the US government or member of the United States Armed Services, or B, the abusive spouse subjected the self-petitioner or the self-petitioner's child to battery or extreme cruelty in the United States. Also, keep in mind that there is no specified amount of time the self-petitioner must have lived with the abuser, nor must the victim live with the abuser at the time the self-petition is filed. Thus, a self-petitioner can qualify even if the victim only lived with the abuser for a short amount of time or only in another country. And question 8, aside from VAWA, are there any other options for relief for abused immigrants? And yes, there are other immigration relief options, such as number 1, conditional residence. Conditional residence means that the USC or LPR spouse filed a petition, the petition was approved, and the immigrant spouse actually received what's known as a conditional green card, and this lasts 2 years. In conditional residence cases, the married couple must together file a petition called a joint petition to remove the condition near the end of the 2-year period. And instead of enduring an abusive or harmful relationship for this period, and hoping her or his spouse will help file the joint petition, the conditional resident may have the option of leaving the relationship and obtaining a special battered spouse waiver to remove the condition. The other option is called the crime victim investigation or prosecution witness, also known as the U visa, and it's for battered men and women who do not qualify for VAWA, for example, because they're not legally married or their abusive spouse is not a United States citizen or legal permanent resident, but they may be eligible for the U non-immigrant status or U visa, which was created in 2000. You can see in the INA 101A15U. The U visa benefits victims of serious crimes who are willing to help in a criminal investigation or prosecution of perpetrators of crime. This visa is not limited to domestic violence crimes committed by LPR or USC spouses. And there are no requirements as to who the perpetrator must be. He or she could be a stranger or a relative, a citizen, or an undocumented worker. The offense could involve sexual attack, physical attack, kidnapping, incest, or many other types of serious offenses. The U visa provides temporary status and can lead to permanent residency. But note that another visa, also known as the T visa, is available to persons who were victims of serious human trafficking. Generally, the person must have been forced into work or been a young person forced to be a sex worker and must meet other requirements. Number 3 is called cancellation of removal for domestic violence under VAWA. And some clients may wish to apply instead for VAWA cancellation of removal because they're not eligible to self-petition or because waiting to gain lawful permanent residence will take too long. So eligible abused non-citizens who are in removal proceedings for any reason can ask the immigration judge for VAWA cancellation of removal. And well, those are all my questions for now about VAWA and alternatives for abused immigrants. And I'd like to thank the attorney for educating us today about this very important and sensitive topic. Our viewers who want to see more videos like this one should subscribe to our Law Watch channel and like this video. And additionally, you can listen to our Legal Thoughts podcast on Apple Podcasts, Google Podcasts, Spotify, or wherever you listen to your podcasts. You can also read our taxation, government contract litigation, and immigration blogs at www.cjacksonlaw.com. And thank you for watching. Take care, and we'll see you next time.